moving on to pre-institution mediation and how some of the benefits of pre-institution mediation in India. Could you tell us a bit more about that topic, please?
Yes, some of the legislations in India have incorporated pre-institution mediation as the norm, and one of the noteworthy ones was the Commercial Courts Act. In 2018, in fact, it came out with its pre-institution mediation rules, and it provides for mandatory pre-institution mediation unless, of course, there is an urgent interim relief that is being sought by the party. So under Section 12A, that's the exception, and you could straight on move on to filing of a suit, or if it's a, if you're any other mechanism that you want to adopt to. But you can skip mediation only in this exceptional circumstance where an urgent relief is required. But for every other commercial disputes, there is a need for pre-institution mediation as mandated under the Commercial Courts Act. So which is a very, very welcome step, because as I said, till things find a way through legislations, it is a very difficult cultural task for stakeholders in our jurisdiction to adopt to some of these mechanisms and understand the significance, importance, and benefits of these mechanisms. That has always been very welcome when it comes through either a court or through a statute. Then we also had the Consumer Protection Act 2019 amendments, which provided for pre-institution mediation and are mandatory in all consumer cases, unless it's a case of medical negligence, unless there is an element of fraud being alleged, or there are cases with a tint of criminality involved. So some of those common exceptions, and medical negligence, of course, for obvious reasons, it requires an expert committee to look at it. So mediation is not recommended. But for every other dispute, it's a mandatory pre-institution mediation. And even while the case is on, it is possible for the district consumer redressal forum, which is entry court for consumer disputes, to send you for a mediation. Or if either of the parties wants to opt for a mediation while the matter is going on, sometimes it is at the stage of evidence where the respondent feels that, oh, there is enough evidence. Maybe I would like to make a settlement offer. And it is, and it has been a very, very successful approach, because when the respondent understands that it's sufficient evidence, and Consumer Protection Act, as you know, is a welfare legislation. It is to protect consumer. It is to ensure that there are no malpractices. There no way consumers are taken for a ride. So it's slightly tilted towards the interests of the consumer. So pre-institution mediation in Consumer Protection Act, although it's a very recent move in 2019, it was happening with the consent of the parties even before, and I think is bringing a lot of positive atmosphere in resolving consumer disputes promptly, and, without really using, although my friends in the profession may not like it, but without really using legal professionals, consumer could simply be able to come out of the dispute by presenting himself before the mediator. And so is the management of the companies. They're not engaging counsels unless it's a dispute before the court, before the mediator, the management, because ultimately a decision has to be taken by the management. Some of these offers are really out of the box offers. They can't be defined under any legal framework. So they have to take a call instantly. So the management sends a person, the consumer presents himself, and the institution has been very, very beneficial. Companies Act also has provided for mediation and pre-institution mediation. NCLT and NCLAT, that is National Company Law Tribunal, National Companies Law Appellate Tribunal, have been empowered to send parties for mediation. So I think the only thing that in my mind which is lacking now would be that these institutions must now maintain a panel of qualified mediators. They have to be trained in the subject matter mediation more than anything else. They could be mediators, trained mediators from various institutions across the globe, but to be able to resolve those subject matter disputes, there has to be an additional training, additional orientation that must be imparted before some of these people can act as mediators. Because, yeah, I mean, in your experience, you would appreciate that although, as we know, mediation is a soft skill, but it comes with a lot of other additional branches of law and additional branches of training that one needs to go through before you can become an expert in one kind of subject matter mediation. So that's something that needs to be taken care of. And recently, Indian Institute of Corporate Affairs, which is a body incorporated under the Ministry of Corporate Affairs, took certain programs, training programs, to train mediators in, bankruptcy, court mediation, consumer protection mediation, etc. So some of those efforts have to be, crystallized, and some of the academies, such as the Mediation Academy, should also look at imparting subject-specific mediation training in future for mediators who are already trained in either civil or family law mediation to gain an edge and be able to contribute in this pre-institution mediation setup.